Hello YouTube. Just want to do a little video tonight. As you all know, back in March the governor of Colorado signed some laws stating that you can't have a magazine more than 15 rounds and a removable base plate and universal background checks. As you all know, that our 55 of our Colorado sheriffs filed a lawsuit on challenging the law and the description of it. And I was just browsing some Facebook today, and our wonderful sheriff, Justin Smith, who's one of our sheriffs in Colorado, just came out with a press release today. So I'm reading this off my cell phone, so you may see me looking back and forth. But anyways, it's kind of long, but I mean it's a good thing. So I'm gonna read it all to you guys. Okay. It says, today the Independence Institute federal civil rights lawsuit achieved its first major success, eliminating the problems that were caused by two vague phases in House Bill 1224, the magazine ban. The Independence Institute, David Kopel, is representing 55 elected sheriffs and one retired police officer in a lawsuit against the new anti-gun law signed by Governor Hickenlooper last March. Tuesday night, on the eve of the federal court hearing, the plaintiffs and the Colorado Attorney General agreed on a proposal to fix the two problems in the magazine ban. First, the magazine ban applies to magazines which are designed to be readily converted to hold more than 15 rounds. This could outlaw some or all magazines with removable base plates. If a base plate is removed and an extender can be attached to the magazine, this will increase the magazine's capacity. The Attorney General agreed to issue new guidance to the state law enforcement that will remedy this problem. The new language says the magazine with removable base plates are only illegal if they actually have been altered so they do not hold more than 15 rounds. Unless so altered, they are not prohibited. So that's a good thing. Second one, the second problem with this has also been fixed with House Bill 1224, requiring the grandfathering owners of magazines to maintain continuous possession. This outlawed many innocent and constitutional protective activities, such as leaving magazines for a gunsmith for 2 weeks while it's repaired, or loaning a magazine to a family member. The Attorney General agreed to fix this problem by issuing additional guidance to law enforcement stating that continuous possession is not only lost by voluntary relinquishment or dominion of control. Dominion is a legal term for the highest level of ownership rights. So if you loan your magazine to your daughter for the week and she does not have the right to sell the magazine, you still have dominion. The practical results of the new language is that owners of grandfathered magazines can now engage in lawful activities with those magazines, including loaning them to family and friends. The grandfathered owners simply may not sell the magazines or give away ownership, which is a good thing too. Second, for the sheriffs, this means they can now return any stolen magazine to its rightful owner, which before, if let's say it got lost or stolen or somebody broke in and they stole your gun with your magazines, police would not give you back your magazine that holds more than 50 rounds because it wasn't continued possession. So that's pretty much just summarizing up that it says that they fixed it, and if something like that happens, then they were going to return it to you. The successful resolution of these issues was achieved by voluntary agreement with the Attorney General. However, that agreement never would have happened without the pressure of the preliminary injunction motion, which we filed on June 10th, as well as our subsequent findings and briefs, because the Attorney General ultimately voluntarily agreed to put these changes into technical guidance, which is binding on the executive branch of the state government. U.S. District Court Judge Marcy Krieger decided that it would not be unnecessary for her to issue an injunction. With these two issues now resolved, we are beginning preparation for a full trial on the merits. The trial will be challenging two of the entirety of the unconstitutional anti-gun laws. House Bill 1224 bans the sale of magazines holding more than 15 rounds. We will argue and present evidence that this violates the Second Amendment as incorporated by the U.S. Supreme Court, District of Columbia versus Heller. The Heller decision forbids bans on arms which are typically possessed by law-abiding citizens for lawful purchase, which will show magazines up to 20 rounds for handguns and up to 30 rounds for rifles are standard for most popular firearms and thus protected under Heller. House Bill 1229 imposes paperwork, fee, and background check requirements on many ordinary uses of guns, such as lending a gun to a friend for a week when he goes on a hunting trip. We will argue and present evidence that this is unconstitutional to treat temporarily firearms loans as if they are firearm sales made by a gun store. Today's success shows that our legal strategy is working. We have removed the problems of the two badly misdrafted provisions in the magazine ban. If we have the proper resources to take care of the rest of the case to a full trial on the merits, we are hopeful that we can liberate Colorado entirely from House Bill 1224, which is the magazine ban, and House Bill 1229, which is universal background checks. I want to say this is a great step forward for us today that we got. Hopefully we can get all these stupid laws taken off, but so far we have a good shot at getting our voices heard. So I will put a link to this article if you guys want to read it for yourself. Put it in the comments section if you guys want to read it. Thanks for listening to my long video. I don't usually make long videos, but I figured this was an important one to get out so everybody can hear what's going on. Thanks for watching. Please like, favor, and subscribe. You guys have a wonderful night. Thank you.